Welcome, everyone, to our conversation today regarding self-represented litigants in America. Joining me today is my co-founder at Quest for Justice, Patrick Forrest. Patrick is also an attorney. So, Patrick, today I wanted to talk about the access to justice gap and how we can help close that gap. For criminal cases, you are guaranteed an attorney. You have no such rights in civil cases. Now, research has shown that the vast majority of people do not have access to affordable legal services. This lack of availability has profound consequences on people's belief on whether they're living in a just society or not. That is, even if the courts are out there to help them get justice, they will not think that they're living in a just society if it's out of reach for them. Now, I don't think that this has always been the case. Can you tell us a little bit more about what has changed in the past 100 years or so?
Yeah, so, I mean, there are massive barriers that sit between the point of when someone first thinks that maybe they have a legal issue and the point where they are in court looking to enforce their rights. Those barriers that exist between those points on the justice journey didn't always used to be there. So the process used to be relatively simple in that, you thought maybe you had a legal issue. You went out, you found your local attorney in town. That attorney helped you understand the law, helped you navigate all the procedural complexities, and then that attorney presented your best case in court. It's no longer quite that simple because, one, we have more procedures than ever with more complexity. We have more laws than ever with a lot more complexity. And lawyers themselves are increasingly expensive, and it just kind of has continued, those price points have continued to increase to the point where, if you are even somebody in the middle class, the chances that you're going to be able to afford a lawyer for litigation are pretty much zero. And that's because when you hire a lawyer for litigation, you're not hiring them for an hour or two. They're just not giving you advice. This is an ongoing service. It's going to take many hours and a lot of time. So that price point for that lawyer is going to be thousands, if not tens of thousands, and for some long cases, hundreds of thousands of dollars. So what's happened now, what we're seeing in the courts now, is that if you look at civil litigation, in 70% of the cases that go through the courts, at least one of the parties there, right, the plaintiff side or the defendant side, is representing themselves without a lawyer, completely alone, trying to navigate that journey.
As a lawyer, can you share what it's like for a self-represented litigant to navigate the civil court system?
Yeah, so Jim Sandman, who is the president emeritus of the Legal Services Corporation, he has a really good quote about this. His quote is that everything about the system, from the language of the law to the forms that are used to the rules of evidence, all of it was created with lawyers in mind. It's a system that works pretty well if you have a lawyer and horribly if you don't. So in today's environment where the majority of people are navigating these legal disputes alone, they're working within a system not designed for them as lay people, as non-attorneys. It's a system designed for attorneys. One of the things I think most lawyers will agree with is that as a lawyer, you can get kind of numb to all of the requests for help that are coming your way from family, from friends, from friends of friends. The need for legal help is absolutely overwhelming, and it can become a little bit much. But what it says to me, the fact that I get requests quite frequently for help with all kinds of legal issues, is that there's a huge need out there that's currently not being met. So you're a self-represented litigant, you're trying to figure it out all by yourself, You're navigating the system on your own. You have to somehow figure out the process. You have to figure out the procedures. You've got to then also figure out how to organize your case, how to collect all the necessary and relevant evidence, and more importantly, and I think this is one of the most difficult parts, you have to present the most complete case possible to that judge in court. So today, as a do-it-yourselfer, you are left on your own to figure it out and to be your own hero, but without any superpowers whatsoever, and very, very limited resources to help you navigate that justice journey.
What do you say that to those out there who says that there are existing self-help platforms for the self-represented litigants?
There are. There are some out there. My criticism, or our criticism, Ben, is that they are disjointed, they are fragmented, and they are incomplete. The reality is that if you're a do-it-yourself litigant, you have to run all over the place, both physically and all over the internet, looking for relevant documents, looking for and trying to learn legal terms, doing your best to understand all the many procedural steps and complexities from that moment where you have to put together your case all the way to presenting it and then maybe collecting on it. And you've got to go and find sample language that you can use and incorporate all along the way. One of the other pitfalls right now is that if you are seeking third-party professional services, like lawyers use all the time at law firms, services that help you provide proper notice on the other party that you're suing them, services that help you mail documents and certify documents, those third-party services, there's nothing out there really available for self-represented litigants, for the person doing it themselves. So those services that law firms and lawyers use to save them time and save them money, they're not available to pro se litigants. And part of the reason that is because it just really doesn't make sense for those third-party services to take on a new client that's a pro se litigant when that litigant may have one case, maybe two cases for their entire lives. They're not going to get reoccurring business from them. So yeah, the solutions out there are certainly piecemeal at best. There's absolutely no kind of one-stop shop that anybody can go to, a pro se litigant can go to help take them all along that journey from beginning to end.
What do you think is the biggest misunderstanding about civil court?
So at Quest for Justice, we work very closely with a panel of retired civil court judges, and they provide an incredible amount of insight to us from the judge's perspective. And I asked one of the judges a variation of this question, and he said that the biggest misconception is that the majority of pro se litigants that appeared before him in court, and this was in California Superior Court, they really did think that that hearing was going to be similar to court reality TV shows that they see on TV. And you can't blame them. That's a lot of people's exposure to what the courtroom experience will be like. But you know, the point he made to me is that if pro se litigants do not treat this process with seriousness and with preparation, they're going to fail. And in many cases, even before that dispute reaches the judge. So, you know, even if a self-represented litigant has access to disjointed information, piecemeal information, they're really on their own to put it all together. So the biggest misconception is that the hearing itself and the process before and after the hearing is going to be a lot simpler than it is, and it's going to be a little bit closer to maybe what they've seen through entertainment vehicles than what it really is like in person. And that's why, you know, you and I and the team of engineers and lawyers that we have at Quest for Justice believe we've got to use technology. We've got to unleash the power of technology to build an online support system for self-represented litigants. And that system has got to do a couple things for it to fill the need that exists right now. It's got to take the user through every step of that justice journey, and that means from helping them identify the legal claim, the law on point, helping them organize their facts, organize their evidence, make sure that they understand what the law requires of them to prove in order to win, and obviously navigate all the procedural complexities where there's a lot of uniqueness. And it has to do those things to help self-represented litigants avoid common mistakes that can result in your case being delayed or result in an additional hearing having to be scheduled. Often when a self-represented litigant gets in front of a judge, if there are kind of procedural problems with the case because the self-represented litigant doesn't know to do this or that, the judge will then have to schedule yet another hearing, and that takes up precious judicial resources. So I think that's the most common misconception and then solution for how to overcome that misconception.
I know that you said that the tools today are fragmented. You have to go all over the place to get it. What tools can I get today from the court system? Do the courts provide these tools today?
Yeah, and some of the courts have done a really good job and have come a long way. So I think California deserves a lot of recognition, the California courts and the California Judicial Council for trying to take some pretty meaningful steps to help close that access to justice gap. So to your question specifically, they've done a lot to standardize and to simplify court forms. They've also done a lot to provide better administrative support from the court staff and from self-help center staff. Making it easier to complete forms and answer questions is really important. But these administrative improvements alone are not enough to close the access to justice gap. Litigants do need tools that help them, like I said, better understand the law, understand the elements of that legal claim, identify the relationship between their facts and that legal claim, so they can make an informed decision on whether to sue, to settle, or to drop the matter all completely. And for those who do conclude that suing makes sense for them, the system ideally will provide those litigants with tools so they can put those arguments together and present what is legally required to the court, again, so as to not waste judicial resources, taking up time for things that are irrelevant to their legal claim. I feel pretty strongly that while many courts have done a lot in the pro se space, there is still so much further courts could go without overstepping that line between providing legal information and giving legal advice to help people who are seeking justice without a lawyer. But that's a much bigger topic, and I think one we'll save for maybe another discussion.
Thanks, Patrick. To close this out, I do want to say that I do agree that self-represented litigants do deserve to get more help in their civil case, and more importantly, to get the justice that they deserve. Thank you for joining me and Patrick today. For more information on the solution that we are building, please visit our website at www.questforjustice.com. Thank you and goodbye.
Thank you.